A patient confesses to murder.
Whoa.
That grabs your attention, right? But today, that dramatic opening isn't actually our main story.
Okay.
Instead, we're diving into a different kind of confession. One argued out in a courtroom, where a lawyer's actions really put a core principle of justice under the microscope.
Right, exactly. So we're not looking at a whodunit, but more of a what did they do specifically within the rules of legal ethics and that really fundamental right to confidential legal advice.
Yeah, it goes to the heart of the system.
It really does. It's about the basic architecture, you could say.
Welcome, everyone, to the Deep Dive. This is your shortcut to understanding, well, pretty complex issues. We wade through the dense stuff so you don't have to.
Mm-hmm.
Our mission today, to unpack a really fascinating case from the Hong Kong Court of Final Appeal back in 2013. It involves a barrister we're calling Mr. Cheng San.
Right, a pseudonym, obviously.
Exactly. And through this real-life legal drama, we're going to explore legal professional privilege, what it is, why it matters, and the kind of tensions it can create when people are trying to ensure justice is done.
Yeah, and the tough ethical spots that even, really experienced lawyers find themselves in sometimes.
So your mission, should you choose to accept it, is to kind of get your head around these nuances, the privilege, how it bumps up against the search for justice, the dilemmas. It's tricky stuff.
Absolutely. Our main source here is the judgment itself. From that case, FACC 102-2012. It gives us a really detailed window into this whole situation where, well, duties and obligations just clashed.
Okay, so what's the central conflict? Boil it down for us.
Okay. You've got Mr. Chung, right?
Yep.
Representing a client in a theft investigation. He ends up being accused of attempting to pervert the course of justice by contacting a witness for the prosecution and trying to claim legal professional privilege, but, and this is key, on behalf of someone else, a third party.
Right. Okay, that sounds complicated already. Let's unpack it. Where do we start?
Well, to really get what Mr. Chung did, you need the backstory, the original legal case.
Okay.
It all started with loans. A Belgian bank loaned money to two companies, let's call them the Mariama companies.
Got it. Mariama Companies, Belgian bank.
And these loans were secured. There were floating charges and guarantees involved from another company, ECT Ltd.
ECT Ltd. And who was behind ECT?
That would be Miss Lau Wingsum. She was a director at a company called Brightway International Group Ltd., which acted as the corporate director for ECT. Crucially, Mrs. Lau was the one who actually signed the charge deed for ECT.
Okay, so Miss Lau signs the paperwork for ECT securing the loans. What happens next?
Well, later on, Miss Lau gets charged with theft. The accusation was that she improperly pledged property she didn't actually have the right to pledge.
Okay, so the loan security itself becomes the center of a criminal charge.
Exactly. And this brings in our key witness, Mrs. Mac Fan.
Ms. Mac, who was she?
She was a consultant solicitor, worked at a law firm, CMK & Co., and her firm was engaged by the bank.
The bank, okay, not ECT or Mrs. Lau.
Right. And Mrs. Mac's role in the original transaction. She witnessed Mrs. Lau sign that very charge deed.
Okay, so the solicitor hired by the bank watches the director of the guarantor company sign the document.
Precisely. And this is where, as you said, it gets complicated. The big question hanging over everything is, when Ms. Mac witnessed that signature, was she, maybe implicitly, also acting as ECT's solicitor, even though the bank was technically her client for that job?
Yeah, that's a naughty one. It's like, who did she owe duties to in that moment? Just the bank. Or ECT too, because she was facilitating their part of the deal.
That's the million-dollar question, legally speaking. It hinges on this idea of an implied retainer.
Okay, hold that thought on implied retainer. Let's bring Mr. Chung back into the picture. Where does he fit in?
So after Mrs. Lau is charged with theft, a different law firm, LC&K, is hired to represent her, and they bring in Mr. Chung, the barrister, to handle her defense.
Right, so he's Mrs. Lau's defense counsel.
Correct. And interestingly, looking back at Mr. Chung's early notes on the case, he actually seemed to spot this potential legal privilege issue quite early on. He noted down questions about whether Mrs. Mac's testimony might be blocked because of privilege connected to ECT.
So he saw it as a possible defense angle right from the start.
It looks that way, yes.
Right.
He recognized it could be a hurdle for the prosecution's case against his client, Mrs. Lau.
Okay. And this leads us to the letters.
Yes. The 3 letters. Mr. Chung drafted them, and then his instructing solicitors, LC&K, sent them off to Mrs. Mac. These letters are really, the crux of the matter regarding the charges against him.
All right, let's break them down. Letter 1, November 2005. What did it say?
Pretty forceful. It stated LC&K were acting for ECT now. It asserted that Mrs. Mack had represented ECT during that loan deal and therefore owed ECT an ongoing duty of confidentiality.
Okay, so directly claiming she was ECT's lawyer for that transaction.
Yes, and it went further. It alleged her witness statements to the police had already breached that duty. It told her to stop any further breaches. And it threatened civil action against her, plus a complaint to the Law Society if she didn't comply.
That's putting the pressure on.
Absolutely. And significantly, they attached something else, a fee note from Mrs. Mack's firm, CMK & Co., billed to ECT for preparing and handling the charge documents back when the loan was set up.
Ah, the smoking gun. Or at least what they hoped would look like one. Evidence of a solicitor-client relationship.
That was clearly the intention. Here's proof you worked for ECT, essentially.
So how did Mrs. Mack react to this first letter?
Understandably, very cautiously. Her response, end of November, didn't flat out agree or disagree that ECT was her client. She basically said, well, it depends on the specific facts, expressing uncertainty.
Hedging her bets.
You could say that. But she strongly denied owing the duty they claimed or having breached it. And crucially, she pointed out she was bound by a witness summons to attend the trial.
Right, she couldn't just decide not to show up.
Exactly. She said unless that summons was officially revoked or set aside by a court, she had to testify. And she put the ball back in their court, saying it was up to them to apply to have it set aside if they thought there were grounds.
Okay, makes sense. So onto the second letter, December 2005. Did they change tack?
Slightly. They attached the correspondence they'd had with the Law Society, which basically said the Law Society couldn't give advice because they didn't have enough facts. Sort of a non-response, really.
Useful.
Yeah. They also referenced the law, Section 34 of the Criminal Procedure Ordinance, which, just as Ms. Mazak had said, puts the burden on the witness to apply to set aside their own summons.
Seems they're acknowledging her point, but maybe trying to arm her with the tools to do it.
Perhaps. And they cited a very important case, R.V. Derby Magistrates Court, Ex Parte B.
Ah, the big one on legal professional privilege.
The cornerstone, really. It emphasizes how absolutely fundamental privilege is. Can't be overridden easily. Mr. Chun used it to argue that evidence covered by privilege isn't considered crucial evidence that would prevent a summons being set aside.
So the argument was, this info is privileged, privilege is super important, therefore you, Mrs. Mack, can get out of testifying.
That seems to be the underlying message, yes. Trying to persuade her she had a strong basis to challenge the summons herself based on this claimed privilege for ECT.
You can really see the legal strategy playing out here, step by step.
Yeah, building the pressure, providing the arguments.
And then the third letter, January 2006, did things escalate?
Considerably. This time they sent copies of the previous letters to the Law Society, formally complaining about Mrs. Mack.
Okay, they actually lodged the complaint they threatened.
They did. They accused her of, and this is a quote, contemptuous disregard for her duty to maintain client confidentiality and privacy, and they formally invited the Law Society to investigate and take remedial action against her.
Wow, that's really turning up the heat, going from threats to formal action.
Definitely a significant escalation. It puts Miss Mack in a very difficult professional position.
And what was Miss Mack doing throughout all this letter writing?
Well, crucially, she kept the police in the loop. After receiving each letter, she informed the investigators.
Which suggests she was feeling pressured or concerned about what was happening.
It certainly indicates she didn't see these communications as just, standard legal correspondence. She flagged it up.
Okay. Fast forward to Mrs. Lau's actual theft trial. The prosecution calls Mrs. Mack to testify. What does Mr. Chung do?
He objects, formally objects to her testifying, citing legal professional privilege on behalf of ECT.
And this is where he uses the fee note.
Yes, he presents that fee note from CMK & Co. to ECT as evidence suggesting there was a solicitor-client relationship. And here's another critical detail that came up later.
Go on.
He supported his argument in court using a single photocopied page from a legal textbook, Blackstone's Criminal Practice.
Just one page.
Just one page. And this became a major point of contention.
Why? What was wrong with the page?
The prosecution jumped on this. They argued that showing just that single page was incomplete and, frankly, misleading.
Misleading how?
Because, they said, it conveniently omitted the next part of the text, which discussed important exceptions to legal professional privilege.
Ah. Like what exceptions?
Specifically, exceptions related to revealing the mere identity of a client, which often isn't privileged, and also the well-known exception for communications made in furtherance of fraud or a crime.
So the prosecution's argument was He's presenting this rule about privilege, but hiding the bits where it doesn't apply.
That was their allegation, yes. That it painted an incomplete picture of the law to the trial judge.
And what happened with the objection at Miss Lau's trial?
The trial judge overruled Mr. Chung's objection. Mrs. Mack was allowed to, and did, testify.
Okay, but the story didn't end there for Mr. Chung.
Not at all. After Mrs. Lau's trial concluded, the focus shifted. Mr. Chung himself was charged with attempting to pervert the course of justice.
Based on those letters and the arguments he made in court.
Primarily the letters, yes. The pressure campaign on Mrs. Mack. Interestingly, the solicitor from LC&K who actually signed the letters, Mr. Young,
Yeah.
he was initially convicted too, but he won on appeal. The appeal court found his personal involvement in actually devising the strategy and drafting the letters was pretty limited. He'd relied heavily on Mr. Chung, the barrister.
So the responsibility landed squarely back on Mr. Chung.
It did. Which sets the stage for his own trial and the appeals that followed, culminating in the Court of Final Appeal judgment we're looking at.
Right. So now we need to get into the legal nuts and bolts. What exactly is attempting to pervert the course of justice?
Okay, so the courts break it down into two main parts. First, the actus reus, the guilty act. This is an act that has a tendency to obstruct or interfere with the course of justice. It doesn't actually have to succeed, just have a tendency.
Okay, an act with potential to mess things up. And the second part?
The mens read the guilty mind. This is the intention to obstruct or interfere. You have to have intended your act to have that effect.
Got it. Act plus intention. Now, how does contacting a witness fit into this? You can talk to witnesses, surely.
You can, but there are very clear lines. The judgment emphasizes this. Witnesses don't belong to any party, not the prosecution, not the defense.
They're neutral sources of information, ideally.
Exactly. So you can interview them, you can ask them what they know, but what's crucial is the purpose of the contact and the means you use.
Right. It's okay to ask, what did you see? It's not okay to say you didn't see that, did you?
Yeah.
Or to threaten them if they testify.
Precisely. The way you approach them and why you're approaching them makes all the difference between legitimate preparation and improper pressure or interference.
Okay. And the other big legal principle here is legal professional privilege. We've mentioned it a lot. Let's define it properly.
Sure. As we touched on with that Derby magistrate's case, it's seen as a fundamental human right, really, not just some dusty legal rule. It's essential for the administration of justice.
Why fundamental?
Because it allows people to consult with their lawyers and be completely candid, tell them everything, without fearing that what they say will be used against them or revealed publicly.
So it encourages honesty with your legal advisor.
Exactly, which means the lawyer can give the best possible advice based on the full picture. It underpins the whole advisory relationship.
And it's the clients, right, not the lawyers.
Yes, that's critical. The privilege belongs to the client. The lawyer has a duty to uphold it, to claim it on the client's behalf, but only the client can waive it, choose to give it up.
Unless there are exceptions, like a law that specifically overrides it.
Right. It's considered absolute unless waived by the client or overridden by statute. Courts generally can't just decide, well, in this case, the public interest in disclosure outweighs the privilege. It doesn't work like that. It's absolute in that sense.
And there are different types.
Two main kinds. Legal advice privilege that covers confidential communications between lawyer and client made for the purpose of giving or receiving legal advice.
Okay, advice privilege.
And then there's litigation privilege. This is broader. It covers communications made when litigation is ongoing or reasonably in prospect for the dominant purpose of conducting that litigation. So talking to potential witnesses, expert reports, that kind of thing.
And in Mr. Chung's case, concerning Miss Mack witnessing the deed signing way back when, which type would be relevant?
That would have to be legal advice privilege. Because when Mrs. Lau signed that deed, there wasn't any active litigation about it, nor was it reasonably contemplated at that specific moment. The privilege claim rested on the idea that Mrs. Mack was giving implied legal advice to ECT as part of the transaction.
Which brings us back to that implied retainer idea. How do courts figure that out? Is it just a feeling?
No, it's more objective than that. The judgment mentions several cases that lay out the test. Things like, you look at all the circumstances, the conduct of the parties. Would a reasonable person in the position of the supposed client, ECT here, think that the solicitor, Mrs. Mack, was acting for them?
So, did ECT reasonably believe Mrs. Mack was looking out for their interests when she witnessed the signing, even if her main client was the bank?
That's the question the courts had to grapple with. It's based on the reasonable expectations derived from the whole context.
Yeah.
Did Mrs. Mack do or say things that would lead ECT to believe she was their solicitor for that specific purpose? The fee note, for example, points in that direction.
But it's not automatic just because she was involved?
No, definitely not. It requires careful assessment of the facts in each case.
Okay, so we have the charges, the principles of justice obstruction, the details of legal privilege, and this tricky implied retainer concept. How did the courts apply all this to Mr. Chung? Let's start with the trial judge who first convicted him.
Okay. The trial judge actually didn't make a final decision on whether the solicitor-client relationship existed between Mrs. Mack and ECT. He kind of said, I don't need to definitively rule on that.
Why not?
Because he felt, firstly, that Mr. Chung didn't genuinely believe the privilege actually existed anyway. He thought Mr. Chung was sort of asserting it strategically, not out of a real conviction it applied.
So questioning the mens rea, the intent behind the claim itself.
Exactly. And secondly, the judge thought that regardless of whether the privilege existed or Mr. Chung believed in it, the methods used, the letters, the pressure, were improper means in themselves, enough to constitute the actus reus of the attempt to pervert justice.
So conviction based on lack of genuine belief and improper methods. What happened at the Court of Appeal?
They took a different view on one key point. They disagreed with the trial judge about the improper means part, specifically regarding just contacting the witness and not telling the prosecution.
Why the disagreement?
They went back to that principle. Witnesses aren't anyone's property. They felt that simply contacting a witness, even a prosecution witness, isn't automatically improper, nor is failing to tell the other side you're doing it. So they didn't uphold the conviction on that specific basis.
But they did uphold the conviction.
Yes, they did, but on different grounds.
Okay, what was their reasoning?
Their reasoning focused much more on the nature of the pressure applied. They concluded that Mr. Chung had improperly pressured Mrs. Mack, who was herself a solicitor, to actively claim a privilege that Mrs. Mack herself clearly didn't believe existed or applied to her.
So it wasn't just asserting privilege, it was trying to force her to assert something she disagreed with.
Exactly. Trying to get her to take steps, like applying to set aside her summons based on a privilege claim she contested. They cited another case, R.V. Rogerson, to support the idea that pressuring a witness in this way could amount to perverting the course of justice.
Okay, so the focus shifts to improper pressure on the witness's own actions and beliefs. And then the final stop. The Court of Final Appeal. Did they agree?
Well, partly yes, partly no. They agreed with the Court of Appeal on one initial point, that the actual substance of Miss Mack's expected testimony, basically, I saw Mrs. Lau sign this document, probably didn't engage legal advice privilege directly. The act of signing and identifying the signatory wasn't confidential legal advice in itself.
Okay.
But then they dug deeper into that argument about the Blackstone's photocopy and the client identity exception. Remember, the prosecution argued Mr. Chung misled the court by hiding the exceptions.
Yeah, that seemed like a strong point for the prosecution.
It did. But the Court of Final Appeal looked closely at the transcripts from Mrs. Lau's trial, what Mr. Chung actually argued. And they found his argument wasn't really about hiding ECT's identity. Everyone knew ECT was involved. He presented the fee note naming them. His point, they concluded, was more nuanced.
How so?
His argument seemed to be that the act of signing the deed was so bound up with the whole process of the transaction, which arguably involved legal input or structuring covered by privilege, that the act itself should be protected. It wasn't about who the client was, but about the potentially privileged context of the signing.
So the signing wasn't just witnessing a signature. It was the culmination of a potentially privileged process.
That seems to have been the gist of his argument, according to the Court of Final Appeal. They pointed out it was actually the prosecution who first brought up the client identity isn't privileged exception during the trial arguments, perhaps misunderstanding the focus of Mr. Chung's objection.
So the highest court felt the prosecution, and maybe the lower courts, had kind of misunderstood Mr. Chung's specific legal argument about privilege at the trial.
That's what they concluded, yes. They felt his argument wasn't the misrepresentation the prosecution claimed it was.
So did they overturn the conviction then?
No, they didn't. Despite finding that the core legal privilege argument might have been misunderstood.
They still upheld the conviction.
Why? Because, ultimately, they agreed with the Court of Appeal's other reason. They agreed that Mr. Chung had attempted to improperly pressure Mrs. Mack to claim a privilege that she, Mrs. Mack, did not believe she actually possessed or should be claiming.
So at the end of the day, Even if his technical legal arguments about privilege were potentially arguable or misunderstood, the way he went about asserting it, the pressure campaign, through the letters directed at Mrs. Mack herself, was deemed improper and intended to obstruct justice.
Exactly. That was the final conclusion. The conviction stood based on the improper pressure exerted on the witness to make her claim privilege against her own assessment.
So if we boil it all down, the big takeaway isn't necessarily about the fine points of whether privilege did apply to ECT via Mrs. Mack or the exact scope of the client identity exception.
Although those are fascinating legal points in themselves.
Right, but the core issue, the reason Mr. Chung's conviction was upheld, came down to the method. The perceived improper pressure on a witness to adopt a position she didn't hold.
That's it. It really underscores that ethical tightrope lawyers walk. You have to be a zealous advocate for your client. Push the boundaries sometimes.
But you can't cross the line into improperly influencing witnesses or undermining the integrity of the process itself.
Precisely. There's a duty to the client, but also a paramount duty to the court and the administration of justice.
Which brings us to a really tough question for you listening. Think about this. In situations like this, where that duty to your client seems to clash with these broader principles of fairness, truth, the proper functioning of the legal system, where should the emphasis lie?
Yeah, is it always client first no matter what? Or do those duties to the court sometimes have to take precedence, even if it doesn't help your client's case?
It's a fundamental ethical dilemma in legal practice. No easy answers.
Definitely not.
We'd genuinely love to hear what you think about that. Where do you draw the line? Head over to our website, maybe our social media channels. We'll put up a poll, get some discussion going on this ethical tightrope.
Yeah, it's worth thinking about. And, for anyone whose interest is piqued, digging deeper into legal professional privilege or the offense of attempting to pervert the course of justice, well, there's a lot more complex material out there.
Absolutely. But hopefully, this deep dive has given you a clearer picture of how these principles play out in a real high-stakes situation. That's our aim. After all, taking the complex and making it understandable.
Hopefully providing that aha moment.
Exactly. That's all for this deep dive. Thanks for joining us. And until next time, keep questioning.